This is LXBN TV, and I'm Colin O'Keefe. A recent ruling out of New Jersey found that an individual who read and used the email of a fellow employee obtained when that coworker forgot to log off the computer didn't break any laws. To explain the case and the lessons for employers, we bring in Michael Schmidt, attorney with Cozen O'Connor in New York and author of their social media employment law blog. First off, can you explain the situation and what exactly happened?
Sure, Colin, thank you very much. It's one of those interesting cases because it meshes an almost classic TV or movie-like set of facts with the current workplace technology and right to privacy issues. You have a school district in New Jersey that provides a central location, an office location for a bunch of computers and allows teachers to come in and use the computers to access their emails whenever they'd like. Even though the school policy says you can only check for work emails, they do understand that teachers will occasionally look at personal email accounts. But like you would see in a TV show and a movie, here you had one particular teacher who went into the room, sat down at a computer, and when he placed his drink next to his computer, he happened to just bump the mouse of the computer that was next to his. And what that did is it stopped the screensaver of the computer next to his, which then showed the inbox of a Yahoo account of one of his coworkers, another teacher who was apparently using that computer next to his, who had apparently forgotten to log out. It just so happens as well that the individual who had his drink bump the mouse noticed in the inbox that there were some subject lines that contained his name. Going back a couple of steps, that individual was involved in a pay scale dispute with the district and was attempting to have a grievance with the association in that school district involving the officers of that association, one of whom apparently was the user of the computer next to his. So when he bumped the mouse, stopped the screensaver, and saw his name appear in the subject lines of the Yahoo inbox, he proceeded to click on those emails, print them out, and then use them at the next association meeting, much to the chagrin of the officers and individuals who were involved in those email communications. Criminal charges which had been filed were ultimately dropped. They proceeded then to file a civil lawsuit among several New Jersey state statutes, one of which is a statute that prohibits the knowingly accessing facilities that have electronic communications such as emails. The lawsuit was filed. The plaintiffs who sued filed a summary judgment motion. The judge denied the summary judgment on that particular statute and said we're going to allow a jury to hear this case. The jury ultimately decided that the defendant did not violate the New Jersey statute that was at issue. The plaintiffs then appealed that decision and lost on appeal. And that's where we are now. Essentially, the jury and then the appellate court found that the defendant did not violate this particular statute.
It's very interesting. So, I mean, if you had to guess, where exactly is the line between what's legal and what's not legal in this case? You know, for example, what if the email hadn't been open, but he had still been logged in? I mean, it sure seems like there's a lot of coincidence involved in this case.
Absolutely. And the critical thing, certainly from a legal or a technical standpoint, is the statute at issue requires that the defendant, here this teacher, knowingly access the email without authorization or to do so knowingly in a manner that exceeds authorization. So what's interesting about the case is the jury did find that he knowingly accessed the email. The issue was that the jury said that there wasn't enough evidence to show that he did it without authorization or that he exceeded any authorization because the evidence simply did not show that the defendant teacher didn't bump into this and look at the inbox and say, well, I must have had some implied approval or some authorization because it was sitting there open for the world to see. There was no evidence that the teacher, for example, hacked into the email system or that the defendant teacher improperly used a password that belonged to the other user. Simply inadvertently or otherwise moved the mouse pad. The inbox was there for the public to see, and because of that, the court found the jury was properly holding that there was no unauthorized access. So where do we draw the line in that kind of case? If there is evidence in a particular case that shows any indication that there was notice that he could not view or could not access the emails, even if the inbox was publicly viewable, that might have led to a different outcome. For example, was there a note on the computers which says no matter what happens, you cannot look at the computer next to you. You can only view things on your computer. The interesting question would then be, well, what if the inbox was on the computer that he was trying to use, and the person using that same computer didn't log out? Or, for example, if the school district had a policy which said you can't look at any other computer or any information on that computer other than the one that you are using. Or, as another example, if the inbox had not been open, what if he had just moved the mouse pad and it was a blank screen, but he could have then clicked into the Yahoo account, which then would have led to him viewing the inbox? Maybe then the court or even the jury might have found differently. And then lastly, as another example, if in fact there was any evidence that he had to use a password or take any affirmative efforts to get into the system or get into this Yahoo account, I think the court and perhaps the jury might have found differently as well.
Mm-hmm. And then finally, what's the takeaway for employers in situations like this? Of course, this is, as you mentioned, almost something like out of a movie with the coincidences that you have, but these types of things do occasionally happen. And what action should employers take to prevent such an odd chain of events?
Sure. And with these kinds of things, it's always a matter of one, communication, and two, enforceable policies. From the employee to employee side of things, it's important for employers to create policy and engage in training on these very issues. You know, we know that companies are now training on anti-harassment, anti-discrimination issues. There should as well be training on effective internet use, effective email communication, not only for those who are engaging in the email communications and the document drafting, but for situations like this. What type of privacy can be expected from people logging onto or using the employer's systems, and what can coworkers do or not do when they become aware that information, electronic communications, may be viewable. The second thing that I think employers can do is also make it very clear through their policies, through their training, what monitoring they are going to be engaged in or reserve the right to engage in. So again, employees have a lesser expectation of privacy when they are using the employer's systems, even to access their own personal non-work accounts.
Very interesting. Yeah, I mean, this is such an odd case, but there's certainly actions that can be taken to prevent this type of crazy coincidental situation from happening.
Sure.
Once again, that was Michael Schmidt of Cozen O'Connor and their social media employment law blog. For more of his insight, be sure to visit socialmediaemploymentlawblog.com. Of course, the intersection of two very popular topics and just a very interesting area, so be sure to check that out. And of course, for more LXBN TV interviews, visit us at lxbn.lexblog.com. Thanks, Michael.
Thank you, Colin.